Welcome back to Legal Snippet Law Simplified. This is our 14th deep dive, and today, for you, the learner, we're tackling a really interesting Supreme Court case.
That's right. We're looking at Vijaya Bank versus Prashant B Narnaware.
And the core question really was about an employment bond, a 2 lakh rupee bond specifically.
Exactly. Was that bond which kicked in if an employee resigned early? Was it an illegal restriction on employment? Or maybe against public policy? That's what we're unpacking.
We'll get into what employment bonds are, liquidated damages, that kind of thing, and what this specific ruling tells us about employment contracts.
And our source, just to be clear, is the Supreme Court's judgment itself. We're aiming to pull out the key takeaways for you, keeping it straightforward.
Okay, let's set the scene. Tell us about Mr. Narnaware and Vijaya Bank.
Sure. So Prashant B Narnaware, he wasn't new to the bank. He joined way back in 1999 as a probationary assistant manager.
Right.
And he worked his way up. By 2006, he was in middle management scale 2.
Then comes this opportunity in 2006, a senior manager role.
Yes, the bank advertised for senior managers, specifically a senior manager cost accountant post. Better pay, a step up.
But there was a catch linked to this bond we mentioned.
Precisely. The recruitment notice itself, in Clause 9W, it laid out this condition.
Which was?
That selected candidates had to sign an indemnity bond for 2 lakh rupees.
An indemnity bond. Basically a promise to pay up if you break a condition.
Yeah, pretty much. In this case, the condition was sticking around for at least 3 years. If you left before that, you'd owe the bank 2 lakh rupees.
Okay. So Mr. Narnaware gets the job, receives his appointment letter in August 2007. Did it mention the bond again?
It did. Clause 11K in the letter repeated the requirement.
Yeah.
Minimum 3 years service or pay 2 lakhs if you resign early, and he signed the indemnity bond.
Got it. But he didn't stay for the full 3 years.
No. About 2 years in, July 2009, he resigned. He got another job offer, it seems, from IDBI Bank.
So he had to pay the 2 lakhs.
He did pay it, yes, in October 2009. But crucially, he paid it under protest. Ah, okay. Signaling he didn't agree with it, even though he paid.
Exactly. And that payment under protest was the springboard for his legal challenge. He went to the High Court.
What was his argument there?
He challenged those clauses, 9W from the notice and 11K from the letter, said they violated his constitutional rights and, importantly, Sections 23 and 27 of the Indian Contract Act.
And the High Court?
They actually sided with him. They struck down the clause, told the bank to refund the money.
Wow. On what basis?
They relied heavily on a previous High Court decision in a case called KY Venkatesh Kumar versus BEMA Limited.
But Vijaya Bank didn't just accept that ruling.
No, they appealed. Took it all the way out to the Supreme Court.
Okay, so now we're at the Supreme Court. What were the big legal questions they had to grapple with?
Well, there were two main ones, stemming from the Contract Act. First, did this bond clause amount to an illegal restraint of trade under Section 27?
And second?
Second, was it against public policy under Section 23? And also, did it violate the Constitution? Let's tackle restraint of trade first. Section 27. What does that generally mean?
In simple terms, Section 27 says agreements that stop someone from practicing their profession or trade are generally void. They're seen as unfair restrictions.
But it's not always that simple, is it? The Supreme Court pointed to some nuances.
Absolutely. They flagged up a really important distinction, one that's come up in earlier cases like Niranjan Shankar Golakari.
Okay, what's the distinction?
It's about when the restriction applies. Is it a restriction during the employment contract or one that applies after the employment ends?
Ah, okay. So rules about not working for a competitor while you're employed versus rules about what you can do after you leave.
Exactly. And the law generally treats restrictions during the contract period differently. The court mentioned another case, Superintendent's Company versus Krishan Murgai, to back this up.
And the thinking behind that difference?
Well, the reasoning is that while you're employed, the employer has a kind of right to your exclusive service. So a clause that ensures you focus on their work during the contract isn't typically seen as a restraint of trade in the Section 27 sense. It's seen as supporting the contract, not restricting future freedom.
So how did they apply that logic here to Mr. Narnaware's bond?
They looked at Clause 11K. They saw its purpose as ensuring he completed the minimum 3-year term in that senior role. It was about keeping him in the job for that period.
Not about stopping him from working elsewhere after leaving.
Precisely. The 2 lakh payment was tied to leaving early from the current job. It wasn't designed to prevent him from taking another job later, like the one at IDBI. So the court concluded not a restraint of trade under Section 27.
Okay, that makes sense. So Section 27 didn't apply. What about the other big argument that the bond was against public policy under Section 23?
Right. This argument focused more on fairness and bargaining power.
Mr. Narnaware's side argued it was part of a standard contract, take it or leave it, and the amount was unreasonable, leading to unjust enrichment for the bank.
Yes, that was the gist. They pointed to the unequal bargaining power often found in employment situations.
Did the court acknowledge that imbalance?
They did. They even referenced a major case, Central Inland Water Transport Corporation versus Brojo Nath Ganguly, which dealt specifically with standard form contracts and unequal power.
And the principle from that case?
The principle is that if a contract term is, unconscionable, grossly unfair, unreasonable, and bad for the public interest, it can be voided under Section 23 as being against public policy.
They also mentioned the Murgai case again here, didn't they?
Yes, reinforcing that employee agreements need careful scrutiny because of this potential power imbalance. Someone eager for a job might agree to terms without fully grasping the implications.
Okay, so the court acknowledged the potential for unfairness, but they still didn't find this bond to be against public policy. Why not? What was different here?
Context became key. The court considered that Vijaya Bank was a public sector bank operating in a changing, more competitive economy.
How did that influence the decision?
Well, they highlighted the need for public sector banks to compete effectively with private banks. This means focusing on efficiency and, crucially, retaining skilled senior staff.
So the bond was seen as a tool for stability.
Kind of, yeah. It was viewed as a measure to reduce attrition, especially in senior roles, and to help the bank get a return on its investment in recruitment and training.
The bank argued recruitment was costly and time-consuming, especially for them.
They did. They pointed out the burden of repeated recruitment drives, which are complex and expensive for public sector bodies bound by fair process rules. Premature resignations exacerbate this. The court seemed to accept this as a legitimate concern for the bank.
What about the amount? 2 lakhs. Was that seen as fair?
The Supreme Court looked at it differently than the High Court. They considered Mr. Narnaware's senior role, his pay package, and concluded that 2 lakhs wasn't so exorbitant as to make resigning impossible.
And the proof was, he actually paid it and left.
That seemed to be part of their reasoning, yes. He could and did pay it to move to IDBI. It wasn't an absolute barrier.
And they also distinguished this case from that Bemmel case the High Court relied on.
Critically, yes. They pointed out differences. In BEM, the clause apparently also restricted future employability, which wasn't the case here. Plus, the argument about public sector recruitment costs wasn't really considered in BEM.
So the message was each case on its own facts.
Exactly. You can't just apply one ruling wholesale to another situation without looking at the specifics.
Okay, so summing up the public policy angle. Considering the bank's public sector context, the need for stability, the recruitment costs, and the specific amount relative to the role, the Supreme Court found the clause wasn't unconscionable or against public policy here.
That's a good summary. They found it wasn't unfair or unreasonable in this particular situation.
Which led to the final verdict.
The final verdict was that the Supreme Court allowed Vijaya Bank's appeal. They set aside the High Court's judgment.
So Mr. Narnaware didn't get his 2 lakhs back.
Correct. And in a related case heard alongside it, they dismissed a similar employee challenge, reinforcing their position.
Right. So pulling this all together, what's the main takeaway for you, the listener, from this Vijaya Bank case?
I think the biggest takeaway is that employment bonds for early resignation aren't automatically illegal in India. They're not per se restraint of trade, nor automatically against public policy.
It depends.
It really depends on the context. Courts will look at the job, the bond amount, the employer's reasons, like recouping genuine recruitment or training costs, especially maybe for public sector employers.
So it's a balancing act.
Definitely. It's balancing the employee's freedom to move jobs against the employer's need for some stability and to protect their investment in their workforce.
And this ruling gives us a clearer picture of how that balance might be struck, particularly for clauses operating during the employment term.
Yes, it clarifies the enforceability in that specific scenario.
What I find really interesting here is how this case reflects the idea that public policy isn't static. It shifts with the economic climate, right?
Absolutely. The court explicitly considered the challenges public sector banks face in a liberalized economy. That context matters hugely.
It shows the law adapting, trying to find that balance you mentioned in light of current realities.
Precisely. And it leads to a really interesting question for you to think about.
Go on.
How does understanding this ruling change how you might view an employment contract with a bond clause? Whether you're looking at it as an employee signing one, or perhaps as an employer considering using one.
Hmm, that's a good point. It definitely adds layers to understanding those agreements.
It does. And if you want to dig deeper, looking into other Section 27 cases or how public policy has evolved in contract law would be fascinating follow-up research.
Great suggestion. Well, this has been a really insightful look into the Vijaya Bank v. Prashant B Narnaware case. Thanks for breaking it down.
My pleasure.